Hi there. We're continuing our discussion of First Amendment freedoms with freedom of speech. And I just want to hit the high points here. There's so much that you can study, volumes and volumes and courses at law school and so forth. But in general, just to give you a little beginning of this, freedom of speech is not absolute. You can't say anything you want to say anytime. Or putting in freedom of expression, adding press to that, you just can't do that. For example, I guess the ancient rule is you can't cry fire in a crowded theater because people will panic and run out and people would be trampled and so forth. So that restricts your freedom of speech. We know that there's something called libel and slander, and that's knowingly saying false things about somebody that you know to be false. And if you say it, it's slander. If you write it, it's libel. So if they can prove that you said this knowingly and with the purpose of causing a person harm, then you can be prosecuted. It's not protected speech under freedom of speech. The court, in trying to deal with freedom of speech issues, has come up with a test that sometimes it uses in trying to decide the cases. It's called the clear and present danger test. Is the speech so close to action that there is a clear and present danger that a harm will occur as a result of the speech, something that Congress has a right to prevent? And then if it is, then it's not protected speech, for example. But things change over time based on what the situation is in the world and so forth and so on. Symbolic speech. A lot of people do something, they don't say anything, but they might do something to indicate their opinions. Here's an interesting case, Tinker versus Des Moines ISD in 1969. This was a deal involving dress code. This was in the middle of the Vietnam War, and some kids in the Des Moines schools went to school one day wearing black armbands. Everybody said, put a black armband on your left arm, and this will indicate that we are opposed to the Vietnam War. Well, this violated the dress code at the Des Moines ISD, and so a bunch of these kids were expelled from school. And their parents filed lawsuits, and they said, you're violating our students' right to freedom of expression. And it went all the way to the Supreme Court, and the Supreme Court said that it was a violation. Just because you're in high school or in junior high school doesn't mean you don't have any expression rights. So this was symbolic speech. Here was another one, Texas versus Johnson in 1989. This was the flag burning case. This came about as a result of the Republican National Convention that was held in Dallas in the 1984, pardon me. And a guy wanted to express his opposition to the Republican Party or the convention or whatever reasons he had. And he took a flag and he actually went up on the steps of a building where a lot of events were happening and set it on fire. Texas at that time had a law against burning a flag, and he was sentenced to prison time. And so he appealed his case, and the Supreme Court said that flag burning was simply symbolic speech. It's his flag, he bought it, and I know a lot of people were upset by it, but it was symbolic speech. Just he was using his expression. When you think of freedom of speech or press, it is freedom not for speech that we agree with, not for speech that we like, but in the words of a Supreme Court justice, freedom of speech that we hate. That's a kind of a hard concept to get, but that's kind of how the court looks at these cases. Let's look at the press, freedom of the press. There's an issue called prior restraint, and this is censorship. How far can the government go in doing censorship on expression of people's writings and of people's films and people's internet and so forth and so on? It's a continuing problem. The court doesn't like censorship very much, and so they really hold these cases to a high standard about why is it so important. The people have to prove, the government has to prove, why is it so important to stop this before people have a right to have a look at it and then judge for themselves in the marketplace of opinion. Now, when you get to this issue, obscenity and pornography, this is an ongoing issue with the freedom of expression, freedom of the press. Obscenity and pornography is not protected speech. But the problem is, what is it? One man's obscenity and pornography is another man's art. for example. And if you ask somebody, you can ask yourself, can you define obscenity and pornography? You'll find it's quite hard to do that. One of the justices on the Supreme Court, Justice Potter Stewart, several years ago, was talking about this issue, and he says, I can't tell you what it is, but I know it when I see it. So I think that's probably everybody's position. But how do you crack down on somebody's art, or whatever they might call it, when somebody else might have a different opinion of that? It's very, very difficult for the court. So in the past, the court has set down several tests when these cases come to them to determine, is something obscene and pornographic. One was called the Roth Rule, and in your textbook, one is called the Miller Test, and community standards. And we've come down kind of to this era right here. Basically what they're saying is the work in question taken as a whole? Don't just go to page 49 and 62 and say, well, these are pornographic pages. You have to look at the whole work. And you say, as a whole, was this created to appeal, under the Roth Rule language, to a person's prurient interest in sex? You have to look up the word prurient to see what that means. P-R-U-R-I-E-N-T. Prurient interest in sex. The Miller Test, a little bit later, came up with the idea that based on community standards, does the work in question have any artistic, political, social, economic, etc., value? Using community standards, does it have any value other than just pornography for pornography's sake? If it does, then the court might rule it not obscenity and pornography and thus protected speech. So we still deal with this, and as community standards change, morals change, the way the world looks at things today, the internet, we have much looser standards than we did, say, 5, 10, 15, 25 years ago. Where the standards have not changed very much, however, is in child pornography. And the government cracks down as hard as it can, every time it can, if anything is done with child pornography. And so the standards are much stricter, and it certainly is not protected speech. So that's just a little bit about freedom of speech. Thanks.